industry, even because for startups in particular, when you're sharing your ideas with people or you want to do things, you just feel that, oh, I need to have an NDA. An NDA is a non-disclosure agreement. And unfortunately, again, a lot of startups and businesses just go online and print something. I've reviewed so many. Some of them you even see between Mr. A and Mr. B. But when you now go down, you see, oh, governing law is American law or law of New York. Or you realize that they just downloaded that from the internet, okay? Or they have a brother or a sister that is a lawyer and just say, please just give me an NDA. I'm going to have a meeting with so-and-so person and I need this. Whilst an NDA is a good idea, you know, if you have an NDA, it's a good idea. It also shows the level of seriousness and it's some form of protection because, again, it's a contract that you can enforce against the parties that have signed, you know. However, the fact that you have signed an NDA doesn't mean that your idea cannot be copied. In fact, it doesn't even mean that your idea cannot be copied and tweaked to such an extent that it becomes a different, you know, expression that it's also subject to protection under the law, okay? I cannot overemphasize the fact that IP does not protect ideas. It protects the expression of your ideas. A lot of times you want to talk to a potential investor or business partner, you arm yourself with an NDA. It's important to understand what exactly an NDA can protect. Excuse me. NDAs protect confidential information. Any confidential business information which provides your startup with a competitive advantage may be considered a trade secret. But for startups, it will include things like your business processes, your algorithms, your clients, your secret ingredients, and so on and so forth. The NDA is an agreement between the parties that signed, like I said. And whilst it's a good practice to have it, know that it doesn't stop other people from applying the information you disclose if it doesn't really qualify as a trade secret. So if you disclose some information and that information doesn't qualify as a trade secret, you know, remember when I talked about trade secret, I said, whatever that thing has to be secret, you have to have taken steps to protect it, and it's something that has commercial value. So if you disclose something unwittingly in your NDA and all that, and the person sees it, picks up that idea, goes somewhere, tweaks it, creates something else, or comes up with something else, okay, then the person would get protection under the law. And when people will come and say, oh, we have an NDA, this and that and that. No. Again, another reason why an NDA is not the best protection for you is that, like I said, again, it's between the parties that sign. So if party A and party B enter into an NDA, that's a non-disclosure agreement, party A goes home and talks to his wife about sue party A, because then you cannot sue party C, I'm sorry, because there is no privity of contract. Privity of contract just simply means that you are party